my name is Saudara.
Hi, my name is Shakil Ahmad Qatia.
Hi, I'm Abri.
Hi, my name is Masira Masifat.
Hi, I'm Farah.
Hi, I am Nabil.
Hi, I'm Joanna.
Company is a legalized entity formed by a group of people involved in business operations. A company is also known as an artificial person, which means it is a legal body that can enter into any transaction just like any other individual. There are two types of companies: private and public, limited and unlimited, parent and subsidiary. Every company has different constitutions. These constitutions must not contradict with the highest level of constitution, which is the federal constitution, the highest law in Malaysia. Law protects one's rights and privileges in the society. All individuals, companies, public authorities, government departments, private institutions, non-governmental organizations are covered by law. Business and companies conducted in Malaysia are subjected to the Companies Act 2016, Act 777.
Every country has got their own rules and regulations that need to be followed accordingly. A person that wishes to start up a company or is already running a company should have knowledge of the laws and the regulations that relate to it. As Mr. Ramesh wishes to start up a company in Malaysia, then he needs to follow the rules and regulations that are stated in the Companies Act 2016.
All individuals in the company or firm needs to at least have the basic information of company law knowledge to establish any business in Malaysia. Company law provides guidelines for companies to function as a legal entity. By following these steps, companies are able to promote their business smoothly and run their companies well.
Besides that, Mr. Ramesh will also gain a better understanding to manage his business if he has the full knowledge of company law. One of the main benefits of having company law knowledge is to ensure the company is operating the way it should. This is because if Mr. Ramesh knows what he or his employees are doing is wrong, he can always refer back to the law.
Another reason why it is important to have knowledge about company law is being able to regulate the company's governance. Having a proper understanding of the Companies Act will also help the members of the company in understanding their roles and duties that they have towards the company. It also limits them to their rights that they have in the company. For example, according to the Companies Act 2016, a director of the company has the right to access the company's legal documents without giving a reason why he requires to do so.
Company law knowledge gives an individual the ability to fully comprehend the concept of separate legal entity. This concept, which is mentioned in Companies Act 2016 under Section 20, states that once a company is incorporated, the members of the company and the company are separated and they represent two distinctive identities.
The company can be protected from manipulation and deceit. There is a chance that they can engage themselves with unlawful activities without them knowing that it is against the law. With company law knowledge, companies can avoid corporate crimes such as false claims and corporate fraud, so they could not be easily fooled.
Another one of its importance is that it can be helpful if the company is facing tribulation of any sort. For example, if Mr. Ramesh or his employees faces an unfortunate accident such as death while on duty, representatives or relatives of the deceased know that they have the rights to claim for workers' compensation. This was reflected in the case of Lee and Lee's Air Farming Ltd in 1961. In this case, Mr. Lee is the owner of the company who unfortunately died while working. His wife, Mrs. Lee, claimed for workers' compensation because, despite him being the owner, he is also the worker of the company.
Procedures are steps or actions taken in a certain way. Setting up a business is not all easy. It requires a lot of patience, perseverance, and a lot of hard work. Apart from that, according to company law in Malaysia, it is compulsory to have procedures, and all organizations and business owners must adhere to these procedures to ensure their companies do not suffer with any complications or legal actions taken by the government of Malaysia.
All companies are required to propose a name for their business. The name of the company must be appropriate as it could affect their reputation as well as the gains to the company. A company's name needs to represent the personality and nature of the business and must not be associated with improper activities. A company also needs to prepare a few alternatives of possible names just in case the original name is declined by the registrar or is taken by another company.
As declared in Section 14, Subsection 3B of Companies Act 2016, another particular that is stated in the form will be the status of the company. Mr. Ramesh needs to distinguish what status of his company he wants to engage in, such as private or public company. Private companies in Malaysia are known as Sendirian Berhad, while public companies are only known as Berhad. Private companies need to have a minimum of one director who is a Malaysian resident, while public companies need to have a minimum of 2 directors who are also Malaysian residents.
Mr. Ramesh will need to clearly state the type of company that he wishes to operate. There are many types of companies. For example, a manufacturing company, a merchandise, whether it be a retail or a wholesale, or a company providing services.
A registered address will be necessary when forming a company. Mr. Ramesh needs to identify the address of his future registered company.
As mentioned in Section 14, Subsection 3 of Companies Act 2016, the details of the third party must have their names, identification, nationality, and their home address. All this must be clearly stated in the superform. Third party consists of directors, shareholders, and the secretary of the organization. Before Mr. Ramesh classifies the shares owned by the members, it is compulsory for him to state the type of company, because the number of shares will differ. If he decides to form a company limited by shares, the type of shares and the number of shares of the shareholders is to be identified. For a company limited by guarantee, they need to state the amount of that each shareholder will have to contribute in case of winding up the organization.
After providing all of the previous details, Mr. Ramesh will also need to provide any other additional information if it is required by the registrar. This is mentioned in Companies Act 2016 under Section 14, Subsection 3J. This is followed by statements from directors or promoters clarifying their agreement to act as a director or promoter and that they must be qualified for this position. This is mentioned in Companies Act 2016 under Section 14, Subsection 4A and B. The directors or promoters must also not be discharged by any other firm and must not involve in any crime. Furthermore, they must also not be in prison within 5 years before the declaration date.
As declared in Section 31 of Companies Act 2016, companies other than company limited by guarantee are not obligated to have a constitution. Besides that, the duties and responsibilities of directors and shareholders are also mentioned in the constitution. Under Section 38, Subsection 2 of Companies Act 2016, the constitution must be signed by the shareholder before submitting it to the registrar.
According to the Companies Act 2016, Section 38, Subsection 3, the following details should be stated. Number 1, that the company is limited by guarantee. Number 2, the purpose of the company. And number 3, the capacity, the rights, the powers, and the privileges of the company. Number 4 would be the number of the members that will be involved with the company. Number 5, matters examined by the demonstration to be remembered for the Constitution. And lastly, any other information that the company wishes to include in the Constitution.
After receiving approval from the registrar, Mr. Ramesh will have to make payment of the prescribed fee so that the registrar may officially register his company. Registrar will officially provide the registration number to the company. After fulfilling these steps, Mr. Ramesh may start to operate his business. Upon incorporation, Mr. Ramesh is required to pay incorporation fees, which differs between company limited by shares and guarantee. For company limited by shares, it is 1,000 RM. Company limited by guarantee, it is 3,000 RM. In the process of registering, he must be honest and the business activities must be all legal.
Mr. Ramesh Ramesh will need to have sufficient capital. Without doing so, he is not able to manage the business operations no matter how ideal his business strategy is. He will need to keep minimum funds at all times in case if the company faces unpleasant events that will lead to the winding up of the company.
Mr. Ramesh will only be able to apply for incorporation to the Companies Commission of Malaysia according to the Companies Act 2016, Section 14, Subsection 1, after completing the following procedures.
As stated in the Companies Act 2016, under the section of 14, subsection 3, Mr. Ramesh needs to provide documentation before submitting the application to the registrar, such as the super form, declaration of directors and promoters, and the constitution of the company.
Consequences are punishments that will take place due to breach of laws. This is made to ensure that the behavior of individuals does not lead to events that will affect others in a negative manner. If Mr. Ramesh disobeys the Malaysian law, he will have to bear the consequences, which varies depending on the offence made.
One of the many consequences that one would have to expect to face is disqualification. This action can be taken upon those who tries to take an advantage of the company's profits. However, this decision must be discussed among the directors of the company.
Another legal action that will be taken upon those who defy the company law will have to face penalties such as finings. The fines vary depending on the severity and violations that have been breached. If the damage done by the company is drastic, then the fines will be as severe as the situation and vice versa.
If one were to abuse their rights and power because of their high position ranking in a company, it is in the power of the court to take legal actions against them. Under the Section 3 Sub 4 of Penal Code, whoever forces labour on any other individuals without their own will, he or she is responsible of the abuse and expected to face punishment such as imprisonment or fine, or both of them in a situation. In this case, if Mr. Ramesh abuses his power as the owner of the company by asking his employees to work overtime without paying them, he will breach the employee rights.
Another consequence is that the court has the authority to freeze or discontinue business operations. This happens in a case where a company is involved in unauthorized transactions, fraudulent projects, and forging documents. Under these circumstances, the company's reputation will be tarnished, which affects the trust among society in a negative manner.
Setting up a company surely requires a lot of time and effort that one must be willing to sacrifice. Company law knowledge provides one with the means to fully comprehend the basic fundamentals of business entities. Rules and regulations exist to ensure that individuals and companies behave the way they should.